Hey, everybody. Gosh, it feels like it's been forever. So, welcome to True Crime Thursday. I've been messing around trying to mess with some of my camera settings to offset the light coming in through this big window over here. I'm not having so much luck with it, and I'm thinking that I may just need a new camera. I've been using this great center camera, which kind of um, sticks down into my monitor, so it makes me look like I'm making eye contact with you, which is a good thing. But I don't seem to be able to get it to adjust for some of this really strong light. So still messing with it, but I'm sure that I'll get it figured out as time goes on. So we have so much to talk about today. I'm looking over here at my other screen because I'm kind of getting things adjusted here for some things that I want to share with you. So, but we have a ton of things to talk about. So I thought what I'd do is go through sort of a case roundup. And then I want to go back and talk about a Supreme Court case that was recently decided that has some impact on both Reed and Delphi. So I want to go back and talk about that. But first of all, I want to do a little bit of a roundup. Now, Karen Reed. There is so much to talk about in the Reed case. Of course, you all know that she is starting her retrial on the 1st of April. And that, of course, means that there has been this frantic flurry of pretrial motions going on. So I wanted to talk about just a couple of them because there is so much. I mean, there are so many motions flying back and forth that we could take a full 2 hours just to talk about Reed motions. But a lot of them have been covered on other channels, so I don't want to take up a lot of extra time with those. Don't know why my microphone keeps muting, but I'm keeping an eye on it. So I don't want to go back and repeat things that other people have said, but I do think there's a few things that I'd like to comment on. So the first thing is really interesting. Now, if you want somebody who's going to go over each one of the motions, read them, comment on them, Melanie Little is your girl. She's a YouTube attorney. If you don't know about Melanie, she's a law tuber, and she's a New York attorney. And she is not only is she very up on the Karen Reed case, but she's absolutely hilarious. So if you have not, if you haven't checked her out yet, please do, because her Karen Reed playlist is probably the most in-depth and extensive of everybody. So, but I did want to talk about a couple of important things that have come up recently. First of all, a former juror who is also a lawyer has now joined the defense team, which is absolutely fascinating. That's the biggest thing that happened this week. Is this former juror? She's also done an interview in Vanity Fair, so you might want to take a look at that as well. And she has now joined the defense team because she was so appalled by the way the case was managed, and in particular, the way the jury was handled. So that one's definitely worth taking a look at. So I'm sure by now that you know that the motion to dismiss for discovery violations was denied. No surprise there. But I do think that it's interesting that Judge Cannoni really made this the hill she was going to die on. I think that there were times that she definitely could have given the defense a little bit more credit, a little more slack, a little more recognition that not everything that the Commonwealth did was on the up and up. Instead, she really just went all in on it, and that was really disappointing. Now, I'm not the only one who has said, y'all know Peter Traeger, the lawyer and he is one of those guys who absolutely tries to be right down the middle, unbiased. And even he has said, this judge has just gone too far. She is too biased in favor of the state. So that was dismissed. The bulk of what she argued was that there are a couple of remedies when there are discovery violations. One remedy is the remedy we saw in the Alex Baldwin case, and that was to dismiss the case with prejudice. And I really think that a different judge might have done that in this case. But the alternative is to grant a new trial. So Judge Cannoni's position was, well, there's no harm, no foul, because she's getting a new trial anyway. So one of the other motions the defense filed was a motion to postpone the trial toward the end of the month, because there is a federal Supreme Court or federal appeals court appeal pending. So they started out by going to the state court, which is the typical way that a state prosecution goes, and then elevated it to the federal court. You can elevate to federal court if there is a question of federal law or a federal right that has been violated. So they are waiting for a decision from the federal appeals court. The appellate court took it up on an accelerated basis, and so a decision could be coming soon. That appeal is on whether or not double jeopardy had attached at the time that the jury decided on two of the counts and hung on one. Now, the problem is the jury didn't communicate that to the judge, and the judge did not communicate to the jury that it was possible for them to find not guilty on two counts and come back with a hung jury on one count. So, interestingly enough, the lawyer who was on the panel was not chosen to deliberate. She was considered an alternate. So what happened was, once the closings were done, the judge then, sort of at random, the way we have seen in other trials, drew out jurors and appointed those 12 to be the deliberating 12. So anybody who was not chosen to be part of the deliberating 12 remained an alternate. So the lawyer who has now joined the defense team, who was on the jury, was not a deliberating jury. So they didn't have anybody on the jury who could say to the jury, it's okay if you find guilty on or you hang on one and find not guilty on two. Judge Cannoni's directions were not very clear in her jury instructions. And so unfortunately, the jury just came back and said, we're deadlocked. The judge then did not inquire of the jury whether or not they had made a decision on any of the counts, and simply declared a mistrial. So that's up with the federal appellate court on whether or not double jeopardy has attached, and we're waiting to find out. So the defense came in and asked for a delay while they wait for that decision. Judge Cannoni denied that motion, but she also said, we're going to start jury selection on April 1st, and it could take a month to pick a jury. So she also did say, and this is true, jeopardy does not attach until the jury is actually sworn in. So you can go all the way through jury instruction or jury selection. You can narrow your pool down to whatever 16 people that are going to be your jury plus alternates. And then you can put that panel on hold and not swear them in. So she is correct about that, just because they select a panel doesn't necessarily mean that they have to swear the panel in immediately. But the longer they wait to do that, the more they run the risk of people dropping out, getting sick, or in other ways not being available to serve after they've been selected for the initial panel. So Judge Cannoni has said that that she may not necessarily swear the jury in at that immediate time once the panel is selected. So one of the most interesting motions that is still pending and she has not ruled on yet is the issue of third-party culprit. So the state came back and said, we don't want them to be able to, they filed a motion in limine saying they did not want the defense to be able to introduce any evidence of a third-party culprit. Of course, we saw this in Delphi as well. I would be happy to explain jeopardy in legal terms. So there is a concept in our Constitution in particular that says that a person cannot be tried twice for the same crime. So the government can't just keep prosecuting you for the same crime over and over again. So the idea is that once a jury is impaneled, then they make a decision and the finding of the jury is binding. And once that jury makes a decision, once that jury is impaneled, no other jury can ever opine on your innocence or your guilt. So, and the findings of that jury are binding and final. It is a concept in our law that favors finality. We want things to be finished and done. We don't want cases that are going to linger on forever and ever and never be final. So the judge favors those sorts of the finality in the law. The Constitution and the law favor finality. So the way it works is that once a jury is selected and impaneled, that means the judge brings them into court, sits them in the jury box, and they are sworn in. They're given an oath of office, the same as many other oaths of office in our country. They swear that they will hear the evidence, determine, be impartial, apply their common sense, and that they will not read or watch any outside information about the case, that they won't do any research, that they won't they won't gather any information outside the courtroom, and they won't talk about the case to anyone, including each other, until the case is given to them for the purpose of deliberation. At that point, that is the jury that is going to make the decision on the facts of the case. Now, the only way that double jeopardy does not attach is if, as in Karen Reed's case, the judge declares a mistrial. And the judge says the jury was unable to reach a decision, or there was some sort of misconduct in the courtroom that leads the jury to call a mistrial. Now, if the judge dismisses the case with prejudice after a mistrial, it means it cannot be refiled, and jeopardy continues to attach at that point. If, on the other hand, the judge says, I'm going to dismiss without prejudice, then the state is free to refile the case. So in Karen's case, the judge declared a mistrial because the jury wasn't able to reach a verdict. There's a lot of questions about which counts and all that, but the judge's ruling was that the jury was deadlocked and she declared a mistrial. And because there was a mistrial, they're free to the state was free to to schedule a new trial and to retry the case. So the charges that were brought against Karen Reed continued. They didn't have to be refiled. She was being charged. She was being retried under the same charges, under the same indictment. And so what the defense argued was that jeopardy should have attached, and it should have been double jeopardy for the 2 counts that the jury found her not guilty on. So unfortunately, Judge Cannoni's instructions didn't tell the jury that they could find her not guilty on each individual count, that they didn't have to be guilty or not guilty or hung on all of the counts. So, and the jury didn't communicate to the judge that they actually had made a decision on 2 of the counts. So it is a gray area, and that's why they have referred it to the appeals court. If I had to guess, the appeals court is going to deny it, and she's going to be retried on all 3 counts. That's my prediction, but you never know. I didn't see the appeal, so I don't know what the defense argued as the basis, the legal basis for their appeal. But the reason why they wanted to delay was if by chance they swear a jury, and then the appeals court comes back and says, yes, jeopardy had attached on those other 2 counts, it's going to throw everything into flux. And in fact, the state might not be able to get that 3rd count, the trial on that 3rd lesser count. So getting back to the 3rd-party culprit, the state filed a motion in limine asking that they be able to keep out any of the 3rd-party culprit arguments. They claimed that there was no specificity as to who they were contending might have been a 3rd-party culprit. Well, the defense came back and they outlined their case for a 3rd-party culprit, and they really they were very specific about the reasons why the actions of these other people would create reasonable doubt as to Karen Reed's guilt. It's a really, really good answer and very thorough. Once again, Melanie Little has a feed from a couple of days ago that outlines where she goes through that kind of line by line. So I don't want to do that today, but I highly recommend that if you're interested in seeing what it is that the defense says their 3rd-party culprit defense is, it's very thoroughly outlined in their most recent answer to the court, to the state's motion in limine. Judge has not ruled on that yet. It's still pending. Now, the judge did throw the defense a little bit of a win. The state had asked, Brennan had asked for Karen Reed's text messages with her attorney, David Yannetti. Now, Yannetti is the Massachusetts lawyer whose license all of the Pro Hac Vice lawyers, Alan Jackson and Alessi and Sarah Little, they're all on, they all came in from out of state to be admitted for this particular case under the supervision or under the license of David Yannetti. So Yannetti's, it's important that he's, that his status as Karen Reed's attorney doesn't somehow get thrown out. So the state, before actually, I think even during and before the last trial, Karen Reed gave several interviews, including an interview with Vanity Fair and an interview with a documentarian for a documentary that actually has been, I think, has been playing right now on Netflix. I'm not positive which platform, but it's been out there. And during one of those interviews where David Yannetti was with her, she commented on some text conversation she had had early in the case with David Yannetti. And the state claimed that her mentioning those in that interview had waived her attorney-client privilege with Yannetti as to those communications. Well, the judge didn't buy it. And I think the reason she didn't was because it's a real slippery slope. Once you give somebody access to attorney-client material, then it kind of opens the door. And I don't think the judge was prepared to do that. Now, the prosecution can still get those statements in through the reporter who did the interview, through the production company and the person who did the interviews. But they can't get it in directly from her text messages with David Yannetti. I don't know that the things that they were seeking are as significant as the state thinks they are. Karen Reed made some comments about early on. She was having some conversations with David Yannetti about, what if I ran over his foot and I didn't know it? What if she was sort of doing the what if thing. And Yannetti was answering her with things like, well, if you did happen to run over his foot and you didn't know it, you would have some culpability. It would be more negligence than any kind of intent, but you would have some culpability. And that's what the state's trying to get a hold of and get in. As I say, they can get it in through the reporter or the interviewer. They just can't get it in by revealing her text messages with Yannetti. They also requested that Karen Reed be able to hear the sidebar conversations through headphones. We've seen this in other cases where when the attorneys go up to sidebar, when attorneys go to sidebar, the client has a right to be at that sidebar and to hear what's going on. So in some courts, what they've done is that they have allowed the defendant to have an earpiece and be able to hear what's going on at sidebar and not have to get up and walk to sidebar. That's particularly good in cases where you have a client that's in custody and you don't want the jury to see this guy getting up and clanking around in his shackles and those sort of things. But the judge said no, that Karen Reed could get up and come to sidebar like everybody else. So that was denied. I suspect this next week, we're probably going to see a couple more motions and a couple more pretrial things come before the court before we finally get to jury instructions, to jury selection. And I expect that we may see some movement from the appellate court as well. You won't know. Nobody will know when the appellate court finally gets around to deciding that the federal appeal. But they did take it up on an expedited basis. They do know that the trial is starting on the 1st. And so I think everybody is hopeful that the appeals court is going to come back with a decision shortly. So the other case that is starting on the 1st of April, April Fool's Day is a good day for trials, is the Vallow case, the Arizona charges for Lori Vallow. Now, she, of course, has already been convicted in, oh my goodness, I didn't know I had a cat in here, but we have a tail on the cat stand. She has also already been convicted in Idaho of the murder of her 2 children J.J. Vallow, age 7, Tylee Ryan, age 16, and Chad Daybell's first wife, Tammy Daybell. She is on trial in Arizona for the murder of her fourth husband, Charles Vallow. Charles Vallow came to Lori's house. They were separated. He came to Lori's house to pick up JJ and for a visit. And when he got there, Lori and her brother claimed that there was some sort of an altercation, that her brother acted in self-defense and shot and killed Charles Vallow. The evidence is pretty convincing that they set Charles up and that it was a premeditated murder and not an act of self-defense. So, as you also know, Lori has decided to be her own lawyer. And that has been interesting, I would say. I will say that for a woman with a high school education, I think she's doing okay. I also think that her advisory council has gone above and beyond trying to help her as she's getting ready for this case. So I think they've done a very good job. Her advisory council's at every hearing, and it's very clear that they have been giving her or sort of giving her ideas for things that probably pretrial motions that probably need to be filed. Now, one of the things that I've noticed, and I think this is probably pretty common in people who are not lawyers and don't really understand criminal procedure, but one of the things that Lori continues to do is she continues to cite federal law, federal rules of procedure, and she continues to use the federal rules as the reason why the court should do something. And that is, it's an improper I don't know why I keep getting muted, but there we go. The federal rules of criminal procedure do not apply in a state prosecution. The state rules of criminal procedure apply. For reasons I don't really know, oftentimes jails have are more likely to have federal rules than they are civil rule or state rules. Sorry. They're more likely to have federal rules and federal reporters than they are state rules in law libraries. But I'm really sorry. I have a cat over here asking to get out the door, and I need to let him out or he's just going to howl, and he's Siamese. Come on, you. There you go. Sorry about that, but you don't want to listen to my Siamese cat yowl for the next hour. All right. So state rules of procedure, criminal procedure, often are similar to federal rules. But as is always the case in the law, state rules can offer more rights than federal rules. They just can't offer fewer rights. So sometimes state rules of procedure are more liberal than federal rules. In general, they mirror one another, but state rules of criminal procedure can be much more liberal and much easier than federal rules. So that's one place that I've noticed that she's sort of making a mistake. She is still at it, though, filing lots of motions. The most recent one is, her most recent ones had to do with her restraints. The judge, she asked to have no restraints. The judge ordered that she will be able to wear a vest. It's a taser vest, basically, under her clothing that will tase her if she gets out of line. But otherwise, she will not be wearing any other kind of restraints. She has been told that she will be able to move around a little bit. She will be able to go from counsel table to the podium, but she will not be able to walk up to witnesses and hand them things. Instead, she's going to have to give things to her advisory council, and they'll be the ones who take things to witnesses or to the bench. So what that means is that the judge is also going to have to require that sort of mirror image for the state as well. So they are not going to be able to approach witnesses directly. They're going to also have to be able to have somebody who takes things to witnesses and all of that. So it doesn't look strange. And it doesn't clue the jury that maybe Lori's in custody, and that's the reason why she can't walk up and directly hand something to a witness. She filed 2 different motions to dismiss. So she's really still on these motions to dismiss. They're not going anywhere. She's not going to get this case dismissed. However, they are kind of interesting. The first one was for violation of her confidential communication and Sixth Amendment rights. Sixth Amendment is the right to counsel. So what she has said is that they have violated her rights because they did not keep her conversations with her Idaho appellate attorney confidential. And I don't think that goes anywhere, but that's her latest. And then the most recent is that she is attempting to have the prosecutor removed because of what she calls prosecutorial misconduct. And she lists several instances of why she thinks that this prosecutor has committed misconduct. Now, I don't think this prosecutor has committed misconduct in the least, but it is interesting that she goes to great lengths to point out that there is or has been, I don't know how Lori knows this, a personal relationship between her and Jose Martinez, I believe is his name. He was the prosecutor who was disbarred from the Jody Arias case. Now, he was disbarred because he was having an affair with a blogger and was leaking information to that blogger that was sealed and the subject of a gag order. And he was also disbarred because of his improper conduct within his office, sexual overtures, those sorts of things. But I think it's amusing that Lori really hauls out the snark and really goes after her as accusing her of having a personal relationship with this guy who's been disbarred for what she characterizes as similar behavior. I don't think it's at all similar, and I don't think it goes anywhere. If you have not seen Lori's interview with Keith Morrison, it is fascinating. But I'll tell you what is more fascinating in my view are the interviews that Keith Morrison did after he interviewed Lori. In particular, Nate Eaton did an interview with Keith Morrison. He's become quite friendly with Keith over the years and may have, I think, was even associate producer or something on this episode with the Lori Vallow interview. And he and Keith sat down afterwards to talk about what it was like to interview Lori Vallow. Now, we all know, because we've been following the case for such a long time, that several months ago, Lori did an online, she had a phone call, which Colby recorded with her son, Colby, and he used it on his YouTube channel. During that interview, Lori told Colby that if you remember, to drop back just a second, if you remember during her sentencing allocution, she said no one was murdered. Accidental deaths happened, suicides happened, fatal drug overdoses happened, but no one was murdered. So now she's taken this further, and in her conversation with Colby, she told Colby, Tylee accidentally killed JJ and then committed suicide. And that is the line that she is continuing to hold, is insisting that this was all Tylee's fault. And so unfortunately, she's hanging it on her dead child. So one of the things that has come up, I think one of the reasons why she decided that she wanted to represent herself was because she wanted this story out. And I think her lawyers said, it's not relevant. The children were still alive at the time that Charles Vallow died. And we're not going to allow you to come in and string this clearly untruthful story. We are not going to in any way, as officers of the court, we cannot ethically allow you to come in and tell what we know is a lie. And so I think that was one of the reasons she decided that she wanted to be her own attorney. So when she reached out to Keith Morrison and wanted to do an interview with him, it was with the purpose of continuing to bring that. Oh, somebody just pointed out in the chat, it's Juan Martinez. He was the prosecutor who was disbarred. I was getting him confused with Jose Baez, who is on the Casey Anthony case and who we'll talk about later. But it was Juan Martinez. He was the attorney the prosecutor who was disbarred in the Jodi Arias case, and who Lori now claims the prosecutor in her case has a personal or romantic relationship with. So I thought what was really interesting about the Keith Morrison interview was the fact that he really curtailed Lori and kept everything on a really tight leash. So when the episode came out, he got 90 minutes with Lori, and I think she just assumed that she was going to be able to get on and for 90 minutes spew her story and get out what it is she wants out in the world. And Keith Morrison did not let her do that. Instead, they structured the episode as sort of a review of the case and of what's happened in the past and what's pending now. And then they interspersed it with some little pretty short sound bites of Lori. But none of them allowed her to air her grievances or manipulate the story in any way. So I gave Keith Morrison some props for that. He did the right thing by not allowing her to get on and be her manipulative self. The last thing is Lori has filed some objections to some of the questions in the questionnaire and also to the state's statement of the case, basically. Saying that she wants very clearly for any discussion of the facts of the case to include the fact that she denies them. So I have this case I want to talk about, a Supreme Court case decision that I think is going to have an impact on future criminal cases and may have an impact on both Reed and Delphi. But before I do that, I want to just do a little case. Guys, I do not know why my computer keeps automatically muting my microphone, but I'm going to have to get to the bottom of it. So I'm trying to keep an eye on it in case it happens again. So to repeat, I wanted to do, before we get to talking about this new federal Supreme Court case, I wanted to do a little wrap up, a little kind of roundup of some of the other cases that we've been interested in. So the first one is James Craig out of Colorado. He's the dentist who is accused of murdering his wife. So there was a preliminary hearing held on the 14th of February. I don't believe that it was live streamed, but the court found that there was probable cause to bind him over for trial, and his trial is set for July 14th. If you will remember, if you'll recall, James Craig also has been charged with, I think am I still muted? Can you hear me? Jen, wave at me if you can hear me. Okay. All right. Okay, good. I'm trying to keep an eye on it because for some reason my computer keeps automatically muting this microphone. So it's more the tech stuff I'm going to try and get worked out as we move along. Back to James Craig. He has also been accused of trying to enlist other inmates within the jail to murder a detective on the case, as well as he has also been accused of talking an inmate who was being released into going out and trying to find people who would claim that they were friends with his wife and that she was suicidal. So neither one of those things flew. He's being prosecuted for witness tampering and soliciting murder in separate cases having to do with witnesses involved in his wife's case. The YNW Melly case, that is Jamel Demons, he's been in custody. You are not going to believe this. He has been in custody since February 13th of 2019. That means that by the time he goes to trial in September 10th of 2025, he will have been in custody 6 years. That is just unbelievable. So he has a new trial set. Now, you will remember his first trial ended in a hung jury. And then there was all sorts of problems and shenanigans with the state claiming that his attorney had been involved in witness tampering. And there was a whole bunch of really unsavory prosecutorial activity going on. And that delayed his case quite a long time. So he now has a new trial for September of 2025. Next, we have Tiffany Adams. Now, Tiffany Adams is the Oklahoma grandmother who murdered Veronica Butler and Jillian Kelly. She is accused of that. Veronica's family recently filed a wrongful death civil case against Tiffany Adams and the other 4 co-defendants. There were 5 total co-defendants in that case. Now, 2 of the co-defendants have rolled over and testified against the other 3 during their preliminary hearings. Well, I take that back, because once they testified against one of the co-defendants, the rest of them waived their preliminary hearings. So there are 2 of them who have flipped. Tad Cullum, who is one of the co-defendant, the remaining co-defendants who has not pled guilty, wants the judge disqualified because he claims the judge represented Tiffany Adams in 2010. Now, this case is set. There's been no trial date set yet, but there is a pretrial conference. The next pretrial conference is set for the 16th of April, and it's likely that at that point they'll set a trial date. I want to say thanks to Rachel Gamber, who has been very faithfully sending me articles and local information on the case, and I appreciate it. It's a case that does interest me a great deal. The whole idea of grandmothers who get involved because of child custody disputes is really interesting to me, whether it's Donna Adelson or whether it's the Piketon massacre, or whether it's this case with Tiffany Adams. There certainly is this sort of undercurrent of toxic grandparents who are willing to do anything to get custody of their grandchildren. So it's kind of fascinating. So thanks again, Rachel, for sending that information. Keep those emails coming. The next case is Corey Richens. Now, Corey Richens is coming up for trial. After we get through Reed and Vallow, Corey Richens is going to be the next one up. She's the Utah mom who is accused of having murdered her husband using fentanyl, and then later writing a children's book about the loss of a parent. So there has been an interesting development. If you recall, she was accused of having attempted to influence witnesses, particularly her mother and her brother, by some letters that she wrote to them. And she claimed that the letters had been sent to her attorney and that they were protected under attorney-client privilege. So the judge ruled this last week that the walk the dog letter, as it's been called, because across the top of it, it said walk the dog and was underlined, that the substance of that letter could come in and be used against her as evidence, and that there were 5 sentences that would need to be redacted to protect her attorney-client privilege that were direct statements directly about conversations or communications she had with her lawyer. Otherwise, the rest of that letter comes in, and it is pretty damning. She essentially is trying to get her brother to tell officials that her husband routinely went to Mexico and brought drugs back, which there's absolutely no indication that any of that happened. There's also absolutely no indication that he used any sort of drugs other than that he used marijuana gummies at night for sleep. And so she has continued to claim that that he got the fentanyl from someplace else. The next one I wanted to talk about is Brian Kohlberger. Brian Kohlberger is the defendant in the University of Idaho murders, and he has been accused. He was identified as a suspect because when the victims were found, there was a sheath of a K-bar knife. A K-bar knife is a particular kind of knife that is used by people who are originally was issued by the Marine Corps to Marine Corps personnel. And when the victims were found, this knife sheath was found underneath one of them. The injuries to the witnesses are consistent with the use of a large knife like a K-bar knife. And when they took DNA, swabbed the K-bar knife for DNA, the button, the snap on the strap that holds the knife in the sheath came back with Brian Kohberger's DNA. Now, his defense team has been attempting for months to attack the DNA evidence in a variety of different ways. They've attempted to attack it by attacking the genetic genealogy process. They've attempted to attack it by in every avenue they can, because it's clearly the most damning information, the most damning evidence that directly connects Brian Kohberger to the scene of the crime. Because Brian Kohberger had absolutely no known connections with any of the four victims. They were all students at the University of Idaho. Kohberger was a master's or a PhD student at the nearby Washington State University. Washington and Washington and Idaho share a border, and the University of Idaho and Washington State University, even though they are in different states, are only a few miles apart across the Idaho-Washington border. So, but one of the things that we did not know until recently was more in-depth information about that K-bar knife. So as the defense has been filing motions in limine, we've discovered some new information. One of the things that has come out is the fact that they have been trying to block the state from introducing Brian Kohberger's Amazon history, his shopping history, his browsing history, all of that information. But in one of the most recent motions, when the state responded to a motion in limine to keep out the Amazon information, they revealed that Brian Kohberger bought a K-bar knife on Amazon about 8 months before the crime. So now we know Brian Kohberger owned a knife like the one that was probably used as the murder weapon. And he owned a K-bar knife sheath like the one that was found at the scene of the murders. Additionally, after the murders, Brian Kohberger went back on Amazon and browsed. His browsing history indicates that he was looking at K-bar knives. So you can draw your conclusion that after the murders, he was shopping for a replacement for the K-bar knife and sheath. Presumably, he got rid of the knife somewhere. And of course, the sheath was left at the murder scene. So it brings to light the fact that this is one of many small pieces of evidence that the prosecution has that we don't know about, that we haven't known about. And it sort of points up that the prosecution likely has much more evidence than we have been privy to. Now, there are some differences. Thinking back to Lori Vallow's case, which was also an Idaho case, there was not a lot that came out at trial that we didn't already know, but there was a reason for that. And the reason was because Idaho and Arizona had been sharing information back and forth about the cases because of Charles Vallow's death and Brandon Boudreaux's attempted murder, and the fact that Lori had fled from Arizona to go to Idaho with the children. So Idaho and Arizona have been working pretty closely together and have been exchanging information. So when people started making FOIA requests in Idaho, and they were rebuffed because Idaho rules say that they don't have to release information until the case is over. If there's an open case, they don't have to release the information. There isn't that exception in Arizona. So in spite of the fact that Idaho didn't release any of the underlying information and evidence in the case, we got a lot of it from Arizona, almost all of it. We saw the text messages, the emails, the police reports. We saw really most of it. So there weren't any big surprises. But now the Kohberger case is in Idaho, and they don't have an obligation to release information. In fact, they are precluded from releasing information pre-trial. So there's a lot more things that we have not seen from the Kohberger case than we saw in the Vallow case. And, you know, I have said from the very beginning, I think that it is really rare that you see a defense attorney come out and say, I believe my client is innocent. Defense attorneys usually say, I am going to defend my client to the full extent of the law. I believe that my client has an absolute right to the presumption of innocence. I believe that my client has an absolute right to mount a defense. All of those things are typical things you hear from a defense attorney. It's a little more unusual to have a defense attorney come out and categorically say, I believe in the factual innocence of my client. And Ann Taylor, who is Kohberger's defense attorney, has repeatedly said that. So it will be really, really fascinating to find out why it is that Ann Taylor believes that he is factually innocent. And it will be really fascinating to see what the prosecution actually can bring to bear. Now, I will say the case was moved out of Moscow to Boise, which is where the Vallow case and both Vallow cases took place, or Vallow and Daybell. The difference is that when Lori Vallow's case moved, the judge from Fremont County came with them. Now, in Idaho, judges have a choice. When the Supreme Court issues an order of change of venue, there is a choice whether that judge remains on the case and follows the case to the new venue, or whether the judge says, I want you to appoint a new judge in the jurisdiction that the case is being transferred to. So in Vallow, Judge Boyce said, no, I want to stay on the case. And it was in his discretion to make that decision. In Kohberger, Judge, who was in Moscow, did the opposite. He said, no, I don't want to remain on the case. And so the Supreme Court appointed Ada County Judge Hippler. And I must say that Judge Hippler is very no nonsense, but he's very right down the middle. And I think that he has done a really good job so far. So I'm kind of looking forward to seeing how he's going to manage the Kohberger trial. I think, though, one of the most stunning things that I discovered on Kohberger is that they have actually set aside that his trial is due to begin on July 11th. And it is expected to continue throughout the entire summer and may continue as long as until November of 2025. So they have set aside from July 11th to November 7th for the Kohberger trial. So that's going to be really interesting. And for those people who are coming from, the creators that are coming from out of town, like Gigi, to cover the trial, it's going to be a haul, because they're going to be, that's going to be a long trial. Now, do I think it's going to last all the way till November? I don't think so. But I think it's going to be every bit as long as the Vallow and Daybell trials. Okay. I have a few more I want to talk about before we launch into questions and into talking about this new Supreme Court case. The next one I want to talk about is Dee Warner and Dale Warner out of Michigan. Dee Warner was murdered. Her body, well, she disappeared, and it was a long period of time that her body, before her body was found. It was discovered in a tank on Dale Warner's property. And he actually had already been arrested for her murder prior to her body being found. But we all know no body murders are much more difficult to prosecute. So, but in a new development, and his trial is set for September 2nd of 25. So we have a couple things that are going to pop off in September. But in a new development, Dale Warner's son, so Dee Warner's stepson, Jaron Warner, was recently arrested, and he's accused of being an accessory to her murder and to evidence tampering. So it appears from those charges that he had something to do with perhaps getting rid of her body. So the interesting quirk in this case is that in Michigan, the prosecution can file a charge as an open charge. And what that means is they leave to the jury whether or not the jury is going to find first-degree or second-degree murder. So it's not really unlike having a penalty phase, because the jury will be asked to decide whether the murder constitutes first-degree murder, which carries life without the possibility of parole, or second-degree murder, which is life with parole. So in some ways, it's kind of like having a separate sentencing hearing, because it's open for the jury to decide what degree of murder he's guilty of. Then we have Shanna Gardner in Florida. Shanna Gardner was the woman who arranged the murder of her ex-husband. It was over a custody dispute. Some really interesting things have happened recently in that case. There is a co-defendant who is actually the gunman, who was the person who they paid to commit the murder. And his last name is Tenen. Recently, when he made a court appearance, he made this very spontaneous outburst with the court that he wanted to recant his admission. Now there has been a whole bunch of stuff that's come of that. Jose Baez, who represented Casey Anthony, represents Shanna Gardner. He's accusing the state of withholding critical evidence. He says that the state circumvented their obligation to give them notice of their intent to depose Tenen and another unindicted co-conspirator that they identify as somebody with the initials JB. And they circumvented their obligation to notify Shanna Gardner's team that they intended to take statements from those people by filing those notices in her co-defendant's case, the co-defendant, her ex-husband. He was her husband at the time of the murders. They also claim that Tennant's attorney withheld information from them and turned over notes to the prosecution that didn't get turned over to Baez and Gardner's defense team. So that one is still sort of up in the air about what's going to happen. Baez is, of course, accusing the state of misconduct, demanding dismissal, yada, yada. Shanna Gardner's trial is set to start October 20th of 2025. And of course, everything has been really thrown into chaos because the co-defendant who previously had admitted that he was the person who had set up the murder scene, he moved a tire into the middle of the road so that the victim had to stop his car and get out to try and move the tire. And when he did, he was shot and killed. He had his 2-year-old child in the car with him at the time. So now that co-defendant is saying he wants to recant his confession that he was the gunman. 2 more cases to look at, 2 Lindsays. The first is Lindsay Clancy from Massachusetts. Lindsay Clancy is the woman who murdered her children and who then attempted suicide by jumping out of a 2nd-story window and ended up being in a wheelchair for life. And she is still in the state hospital. Her attorneys have filed a notice of their intent to rely on the insanity defense for her. They have claimed all along that she suffers from postpartum psychosis, similar to Andrea Yates a few years back. Her trial originally was supposed to start in December of this year, now has been moved back to January of 2026. Lastly, I want to talk about Bahama Mama, Lindsay Shiver. So Lindsay Shiver is the Alabama woman who was in the Bahamas with her paramour at the time that and was arrested there because she and her paramour and another man, are accused of conspiring to kill her husband. So they were in the middle of a very ugly divorce and a very ugly custody battle. The husband is from an extremely wealthy family, and they owned a vacation house in the Bahamas that they used to fly to on their private jet. Back on February 13th let me back up more. Back on October 24th of last year, her bail was revoked. So she was arrested in the Bahamas. She was held at Fox Hill Prison, which is absolutely abysmal. It is a 3rd world prison. It appears that the conditions for the women is better than conditions for the men, but the conditions are overall very bad. It is vermin infested. The food is horrible when you can get it. And the Bahamas is rife with corruption among law officials as well as jail officials. And so it is not a great place to be in prison. It is rated one of the top 10 worst prisons in the world. Okay, so that's pretty bad when you think of some of the African and South American prisons as well. So she was released on bail not long after she was originally arrested. And she was allowed to go back to the United States. She had to wear an ankle monitor, and she was required to live with her parents and to not have any contact with her ex-husband, who's the alleged victim. And I think she was allowed to see her children, but only supervised by her parents, and she was living with her parents. Then in October of 2024, she showed up in the Bahamas for a hearing, for a pretrial hearing, and she had a production company in tow. Now, it's not clear at this point, to me at least, who that production company belonged to, because she appeared on both Good Morning America and Inside Edition. So when she appeared in October, she had this film crew with her. Now, the Bahamas is very, very strict on pretrial publicity, and the judge had already issued a gag order saying that they could not talk about and could not speak to the media about the case. So the judge was not very happy when Lindsay showed up in Nassau with a film crew in tow. So the judge ordered her held, had a hearing about revoking her bond, and in fact did revoke her bond. Now, one of the things that means is that if your bond is revoked, the judge can and likely will take your security money. If you violate your bail, you forfeit any money that you have posted as bond. So whatever happened with Lindsay, she also had to forfeit the bond money that she had put up. So from October of 2024 until the 13th of February of 2025, so several months, she continued to be held at Fox Hill. Then on the 13th of February, she was re-released and granted bail. Now, that very likely means that she had to post a second healthy security amount in order to be released. But she was released on the same terms, meaning that she could return to the US and live with her family. Her co-defendant boyfriend was also released because his bail was also revoked because of the pretrial publicity. So I'm sure Lindsay is more than happy to be out of Fox Hill. So before we go to questions, I want to talk a little bit about, and I'm going to put this up on my screen so I can talk about it. I'm going to take myself off the screen so everybody can see this. This is a U.S. Supreme Court decision out of a case that started in Oklahoma. And I will scroll through this and we can talk about it. So let me just sort of set the scene. The defendant was accused of murder. This is he's the Glossop in this case. That's his last name. He was convicted and sentenced to the death penalty. The only evidence that supported that conviction was the testimony of a co-defendant. And that co-defendant I have a cat. I have a cat wandering around on my desk. So the only real evidence to convict him was the testimony of his co-defendant. The state appeals court overturned his case because the defense attorney was ineffective in challenging the co-defendant's testimony, and they remanded it. It was ineffective in challenging that and challenging the corroborating co-defendant's statements. So he got a retrial, and the co-defendant gave varying stories that were different from the testimony in the first trial. And the defendant moved for a mistrial because of the state's failure to notify the defendant of the changes in the co-defendant's testimony. Now, I want you to think back to Delphi. In the Delphi hearing, when they got to trial, the medical examiner came in and testified that he now believed, although this information had never been given to the defense, he now believed that the girls' throats had been slashed with a box cutter. That was the first mention of a box cutter. That is a red flag because there were statements by other potential third-party culprits about the use of a box cutter in the crime. And had that come out in pretrial, it's possible, although we are talking about Judge Gull, and it cracks me up because Melanie Little always says, you thought Judge Gull was biased. Judge Cannoni takes one look at her and says, hold my White Claw. However, it was possible that Judge Gull could have found a nexus, the connection to the third-party culprits. Had they known that information, the defense could have argued that. So this decision may have some significance for Delphi. This decision, the U.S. Supreme Court decided it on the 25th of February of this year. So it is a brand new decision. What that means is that every defendant every lawyer who's recently had someone convicted is going to be looking at this decision and seeing whether or not this newly decided law could support a retrial in their case. So what they said was there were concerns about the integrity of the conviction. So later on, after the second trial, so after his retrial, the appeals court upheld the conviction over their motion for a mistrial because of the prosecution's failure to disclose the new testimony from the co-defendant. A group of state legislators that was concerned about the integrity of the conviction created an independent commission to investigate the case. And as a result of the investigation, the state attorney general admitted that they had knowingly, that the prosecutor knew about and knowingly solicited false testimony and failed to correct it. So there it's a little bit different from Delphi, but I would submit that it definitely has overtones that are going to come in Reed. So what happened in Glossop was that the co-defendant, that the state portrayed this co-defendant as a puppet, as sort of a peaceful guy who would never have, he was nonviolent and he was just a puppet of Glossop's. But the evidence came out, previously undisclosed evidence, that he was severely bipolar, that he took medication for his bipolar disorder, and that his diagnosis came with a risk that there would be, that he could be violent. So, and there was a suggestion that the co-defendant had considered recanting his testimony at some point, and that information was not provided to the defense. So let me just scroll through here because I want to point out some things. Now, this was written by, let me see. This was written, the decision was written by, I believe it was written by, I just had it up here. It was written by one of the more liberal judges on the panel. It'll come up here. It wasn't Elena Kagan. So I just want to zoom through to where I have highlighted some things. So one of the things that's always a question is whether or not the federal government has jurisdiction. Oh, it was Sotomayor. Thank you. And one of the questions is always whether or not the federal government has jurisdiction, particularly when, as we've talked before, they're reviewing the results of a state court prosecution, a state criminal action. Now, the only way that they get jurisdiction is if there is a federal question that that can't be adequately answered at the state level. So what they held was the independent and adequate state ground doctrine precludes the court, keeps the court from considering a federal question if the state court's decision rests on an independent and adequate state law ground. So the first thing that the US Supreme Court had to find was that there was no adequate state law ground on which this question could be decided. Hopefully that makes sense. So the next thing they had to do is they had to go back and look at a case that has precedent called, I'm going to butcher this, NAPQ, I think. Napui, maybe. Napui. And what that case said was a conviction obtained through the knowing use of false evidence violates the 14th Amendment's due process clause. To establish a NAPUI violation, a defendant must show that the prosecution knowingly solicited or allowed false testimony to go uncorrected. If a violation is established, a new trial is warranted if the false testimony could this is important, in any reasonable likelihood have affected the jury's judgment, meaning ordinarily that the prosecution must establish harmlessness beyond a reasonable doubt. Now, we have talked at length about harmless error, and that is the no harm, no foul position that courts often take. And the Supreme Court is very likely to use that no harm, no foul justification. But what this court is saying is that the weight of the evidence, the burden of proof drops solely on the prosecution to prove that whatever they put forward as falsehood is harmless beyond a reasonable doubt. That is a really high standard. So what Judge Sotomayor said was, hence, there is a reasonable likelihood that correcting Sneed's testimony, Sneed was the co-defendant, would have affected the judgment of the jury. So what they're saying is that if the prosecution had corrected the information and allowed and let the defense know that there was a challenge to his credibility, that there was some question about whether or not he was actually the innocent puppet, the non-violent puppet that the state had portrayed him as. If that information had been presented to the jury, it was likely that it could have affected the outcome. There was a reasonable likelihood, because words matter in the law, a reasonable likelihood that it would have affected the judgment of the jury. So consequently, the prosecution's failure to correct the false testimony entitles Glossop to a new trial under NAPUI. The due process clause imposes the duty to correct false testimony on the state, not on the defense. So I think that there's a good chance there can be some appellate issues raised both in Delphi and in Reed having to do with whether or not the prosecution corrected what was patently false testimony. And I think we're going to see this issue brought up in both of those cases. And I think that we're also going to see in other cases, previously decided cases, we're going to see lawyers bringing back challenges to their clients' convictions based on this new ruling. Because what it does is it expands the decision in Nipui. And when a court expands the right of somebody, then lawyers are going to go back and look at the facts of their recently decided cases and say, wow, can I shoehorn this into my appeal? So it also says Nipui does not require that the false testimony itself must have directly affected the trial's outcome. Nipui requires assessing whether the prosecutor's failure to correct the testimony could have contributed to the verdict. So it is definitely a more liberal statute. Of course, we had some dissenters who filed. We had Judge Roberts, Keegan, Kavanaugh, and Jackson joined in. Barrett, Amy Coney Barrett joined in as to part 2, so they can adopt all or part of a decision. Amy Coney Barrett filed an opinion, a concurring opinion, an opinion that concurred in part and dissented in part. And of course, Thomas and Alito filed a dissent. Gorsuch took no part in the consideration of it. So I think this is going to have an impact. Let me pull that down. I think this is going to have an impact. I don't know here we go. Hello, I'm back. I don't know. I think this is going to have an impact on cases, not only cases that are pending, but cases that have been recently decided. And I think we are going to see glossip challenges in both Reed and in Delphi. So with that, I think we're ready to take some questions. I hope that was interesting. I've been trying to look for things that you might not see on other feeds. I know that there's a lot of coverage happening, particularly on Reed and on Vallow, as should be with those trials coming up right away. So, but it's always interesting to get a different perspective as well. So I think we're ready for questions. So tell me while we're doing that, I want to talk about a few things while Jen's lining up questions. First of all, you see we have a little bit of a new look and a new name. That is because I'm going to continue this channel beyond Lori Vallow and Children of Darkness and Light. I have loved having that be our identity, but I think as we move on and as I move on to new projects, it seemed like a better fit to sort of give us a rebrand. So you will find us as Chasing Justice. And I'm still on, I am on Blue Sky, I am on Instagram, and I am on Facebook. The Facebook group is still called The Good Lori. And so if you are a member of the Facebook group, you shouldn't see any disruptions. And if you search my name, you're still going to find me under Chasing Justice. But it seemed like a way to begin to transition into new projects. I do have a new project I'm pursuing, and I'm not quite ready to make any announcements yet, but I should be soon. So I will tease you with that. I know it's annoying when people say, oh, I can't tell you yet, but it's a secret, but wait till you hear. But that's the case. I don't want to tip my hand until I'm sure that we have, that I have it kind of buttoned down. But when I make an announcement on the new project, you all will absolutely be the first to know. So I also want to talk about, I got invited to the Tucson Festival of Books. Now, for those of you who are in Tucson, you knew this was a really big deal. I knew it was a big deal to get invited, but I had no idea how amazing it was going to be. So not this last weekend, but weekend before, I went down to Tucson. The festival runs over the weekend. They invite 400 authors with new books out, with books that have come out in the last year. And those authors are, many of them are invited to panels. I was, not all of them, but many of them are. And they set up in the University of Arizona quad. And the University of Arizona, all the buildings are sort of built around this huge grassy infield quad. And it is easily a football field and a half, if not 2 football fields long. That entire grass area was set up with aisles of white tents. There were big publishers, small publishers, individual authors, writing guilds, other artistic groups. It was phenomenal. The volunteers are fabulous. The organization is so clean. So I got there the first morning. I walked into the area where they were hosting authors. It was sort of a restaurant bar area right on campus, right in the main student union area, and checked in. I got a name tag. I got tickets for lunch both days. I got a schedule of my appearances, and I got to meet all the other authors that were there, which was pretty cool. I ran into Joel Waldman, who was there with his book, Surviving the Survivor, about his mom being a Holocaust victim, his mother, Carm. Also ran into a couple of other authors that I had met over the time and got to know some of the people who I was on the true crime panel with. The first panel was me, a guy who wrote a book, wait a minute, Frank Fazuli, who wrote about the FBI and who recently wrote a book called Long Haul about the FBI's continuing investigation and the investigative team that investigates serial murders among long haul truckers. So that was really interesting. The other guy was a guy who wrote a book about drug trade in the Florida area in South America. And then the next panel I was on was a gentleman who had written a book about a child murder that happened in the 1930s, kind of like the Lindbergh baby. And also Lisa Belkin, who wrote this really interesting story where it's called Genealogy of a Murder, where she follows 3 immigrant families whose lives collide when one police officer, one doctor, and one murderer come together in the murder of the police officer. So it's really interesting. She talks about how their lives and the way that they were raised and the good or bad things they faced all came together in the confluence of this crime. It's really, really a fascinating story. And it is the man who was the doctor was her stepfather. And she first learned about the story when he told her the story. So that was super good. Um, we were hosted and taken care of the whole time. I, of course, came back with a suitcase full of books, most of them autographed, because it's so much fun to go and talk to other authors and meet other people. And it was really, really fun. Way more exceeded my expectations. The city of Tucson actually expects 140,000 people a day for 2 days to come through the Tucson Festival of Books. So if you ever get the opportunity to attend the Tucson Festival of Books, it is more than worth it. There were continuous panels, 4 or 5 at a time, all day long, going on with authors, everything from children's books to YA to fantasy to fiction to chick lit to you name it. It was really amazing. So that was great fun. And then last weekend, I was invited over to Boise. Those of you who've been with me a while know that I lived in Boise, or Meridian, which is a suburb of Boise, for a couple of years while I was writing the Vallow book. And so I went over to Boise to Rediscovered Books and did a book signing with them on Tuesday night. It was super fun. I was so excited to see some of my friends that I met while I was there, Julie and Cheryl. I had dinner and brunch with them, saw Victoria, we had cocktails, and I was able to catch a quick breakfast on my way out of town with my old neighbors. So it was really fun. Rediscovered Books did a really nice job. There were about probably 20 people there, and we had a really good conversation. And now I have some thank you notes to write. So it's been a great 2 weeks, but I missed all of you because I haven't had an opportunity to get online. It seems like Wednesdays have been my travel days. So I'm glad to get back together with you. And I think we're ready to answer some questions. Jen, what you got for me? Hey, Susie Gay. Any thoughts on why she does not want Nate Eaton in the courtroom? It seems to be the reason he's on her witness list. Yes, I agree. So Lori Vallow put Nate Eaton on her witness list. And for those of you who might not know, Nate is the reporter. I think he's the investigative reporter for East Idaho News, which is a digital news reporting agency in Eastern Idaho. And Nate has really been on the Vallow Daybell case since the very beginning, since Lori went missing and they went looking for her in Hawaii. Nate was there. So I think it's very difficult to see how Nate Eaton has anything relevant to say about Charles Vallow's murder, because he didn't even know about the case until long after Charles was murdered. Charles died in July of 2019. And Lori didn't move to Rexburg, and the whole Eastern Idaho connection didn't happen until September of that year. And then I don't think Nate really had any idea, had an inkling about the case until the first reports that Lori was missing and her children were missing. And that would have been in November of 2019. So months after Charles Vallow had already died. I do think that she's decided, because she's very revengeful, that she wants him out of the courtroom. And he'd already announced that he was going to be there for the trial. So I think that she listed him as a witness because she just wanted to invoke the rule of sequestration and keep him out of the courtroom. I do not think that a judge is going to order him out of the courtroom because he's on her witness list. So yes, he does have to be served with a subpoena. The last I heard, he hasn't been served yet. And my understanding from the quick little YouTube short I saw was that he intended to file a motion to quash any subpoena that she served him. I think a judge will order that. I think a judge would quash a subpoena because I think her sole reason for bringing him, for putting him on her witness list is to exclude him. Absolutely. There's nothing I can wrap my brain around that would make Nate Eaton a relevant witness in Charles Vallow's murder. There's just nothing there. So I can't see a judge leaving him on, and I definitely could see a judge quashing that subpoena. I think it's just Lori being spiteful. So good question. Who is giving Lori this information about who the prosecution's boyfriend is? You know, I have no idea. I wondered the same thing. But let's remember that inmates within the jail system have nothing else to do except to spill the tea. So it's not surprising that that kind of information is floating around in the jail as to whether or as to who her boyfriend is. I will say that when he was disbarred, it was big news, and it certainly was big news in the Phoenix area. It was a big deal. He was accused of some pretty serious malfeasance, and attorneys, I mean, the bar's first recourse isn't usually to disbar somebody. Usually the bar is going to try and find a way to punish someone and still reserve their license. So disbarment is a punishment that's kind of reserved for the worst. And he was straight out disbarred. It wasn't even one of those things where he resigned before he was disbarred. So, which I do believe Kirk Nurmi resigned before he was disbarred, and he was Jodi Arias's defense attorney. So both defense and the prosecution were disbarred as a result of Jodi Arias's trial. In Kirk Nurmi's case, it was because he wrote a book about it, and the bar believed that he had disclosed attorney-client confidences. So, and that's a no-no. That's why you rarely see a lawyer who has represented a client writing a book about the case where they represented that client, because it's so easy to step over that line and reveal confidences. So that's why I have said all along, I didn't think you were going to see a book from John Pryor, because I just don't think he's prepared to take that on. So, but we don't know who gave her the information. If I had to guess, it's probably just scuttlebutt from the jail. And I don't know whether it's true or not. I don't know if Lori knows whether it's true or not. Hi, I did read her decision on the motion to dismiss. We didn't go through it line by line because it came out a week or so ago, and I kind of jumped to the conclusion that folks had already seen it on other creators' feed. I did say, if you haven't been through it, Melanie Little did an entire episode pretty much on her decision on the motion to dismiss. So what I will say about it is, I think that she could have been a little bit more down the middle of the road. I mean, I never expected that she was going to dismiss the case based on this motion, because she's just too far in the tank for the state, for the Commonwealth. But she could have been a little more even-handed about it. And I was surprised at how clearly this decision really transmits her, telegraphs her bias. And And I think Melanie Little was right in saying, is this the hill you're going to die on? This is the case that you're going to stake your reputation on? This is the case that you're going to do that? So, I don't think she comes off looking good in it. And I think it just gives the defense more fodder to appellate fodder for a clear judicial bias. So we'll see. But I highly recommend that y'all take a look at it. And as I say, Melanie did a really good job of going, kind of line by line through the decision, and she's hilarious. So, it's worth listening to her for her comments. I don't know how it's been for you all, but we had a couple of really nice days. When I was in Boise, it was almost 80 degrees. And I understand it was about 80 degrees here. So we're just starting to get some decent days. But then today, we had thunderstorms this morning, and rain blowing sideways and wind blowing sideways, to the point when I went out earlier this afternoon, the whole street was full of tumbleweeds. I mean, not just one or two. The whole street was full of tumbleweeds, and they were blowing around in the street. That's what happens when you live in the high desert. You get tumbleweeds. Question: when you put someone on your witness list, do you have to provide a short summary of what you expect them to testify about? I have seen that in a high-profile case in Oklahoma, Daniel Holtzclaw. This is a good question. It depends a little bit on the state's criminal rules of procedure. But typically what happens is the people who are going to go on the state's witness list are going to be people who they already have statements for them. They're going to be witnesses. Whether they're civilian witnesses or whether they're law enforcement, they're going to be police reports. So you're going to have a police officer who talked to an eyewitness, and that eyewitness statement is going to be in a police report. Now, in some states, like Indiana, you're allowed to depose witnesses before trial. A lot of states, my home state, Oregon, doesn't allow criminal depositions prior to trial. So what you get is going to be based on any law enforcement witnesses, going to be based on their reports, or it's going to be based on any interviews that the defense's investigator might have done with lay witnesses. So the only place that is an exception is if the person who's on your witness list is an expert. So generally what happens in a criminal case is there are two different deadlines. One deadline is earlier, and that is the deadline for each side to provide a list to the other side of the expert witnesses that they intend to call. And for those expert witnesses, they must provide information about that expert. So typically that means curriculum vitae, and it also means any reports or any evaluations that expert might have done. So for example, in Reed, where we have the crash daddies, the ARCA crash experts, they were required to provide all of the information about their reports. There was something like 3,000 pages of information that they produced about their evaluation, including a very detailed report. That all had to be exchanged with the other side pretty early before trial. The remaining witnesses that are non-experts, all that has to be provided is their name, their address, any contact information either one has. And it's really up to the defense then to figure out whether or not they have information already in the discovery about that witness. For example, if they're going to call, if Karen Reed's case is going to call Officer Buchnick, there's a ton of reports about what Officer Buchnick did during the Reed investigation. So that's what they go on. Now, like I say, in some states, like in Indiana, the defense was allowed to depose. The prosecution had a right to be present, but they did depositions to depose even the law enforcement witnesses, even witnesses, law enforcement who'd already written reports. So it varies a little bit from state to state. But as a rule, you get police reports, you get any police and interviews of lay witnesses, and then the defense has the right to have their investigator go out and talk to people. The sticky part about it is that most of the state rules in most states also say that witnesses are not obligated to talk to the defense. So sometimes your investigator gets out there and just gets stonewalled. So, but that's a good question. It may be the case in some states that there is some short summary required of what that person is going to testify about. But that would be probably be the exception and not the norm. Hi, Beth. In the prosecutor's response to a motion by Lori Vallow, that prosecutor stated she spoke with Nate Eaton and told him he could be excluded from the courtroom just because he's on the witness list. Yes, that's true. So in every case, one side or the other, or both sides have the right to invoke the rule of sequestration. That means that people who are anticipated as being witnesses can be excluded from the courtroom until after their testimony. If you remember, in Lori Vallow's case, it came up because the state of Idaho had a very clear delineation of who a victim and victim's family is and who it's not. And in Idaho, victims and their families are excluded from the rule of sequestration, meaning that they can be there while the case is going on, even if they are on the witness list. But in most cases, either side or both sides can say, we would like to have witnesses excluded. And then they would not be able to come in and test until after they had testified. And Lori has sort of jumped to the conclusion and interpreted the state's conversation with Nate as somehow telling him how to avoid being served with a subpoena. But I don't think that was it at all. I think the state did, in fact, caution him that he could be excluded if he was on her witness list. And that Nate's free through his own counsel, not through the state, not through Lori, but Nate is free through his own counsel to file a motion to quash any subpoena that Lori might serve on him. And he's already said that he intends to file a motion. So I don't think there's any hope that Nate Eaton is going to be excluded from the courtroom or that he's going to be called as a witness. I think she's just spiteful and she didn't like his coverage. And so there you are. So it doesn't matter if Nate gets a subpoena. Well, it does matter if Nate gets a subpoena. If he gets a subpoena, he will need to comply with the subpoena, or the court will need to quash the subpoena. So the next step, if he gets served, will be for Nate's lawyer to file a motion to quash the subpoena. The court will hold a hearing and will determine whether or not his testimony is necessary and whether or not he should be excluded. As I say, I cannot see any universe in which Nate Eaton has any relevant information for the court. And it is not as if this judge hasn't seen attempts to exclude people by putting them on a witness list. So I just don't see that it's going to happen, but he will have to respond to a subpoena. And, you know, in part, maybe that's part of what Lori wants too, is just to cause him the inconvenience and the expense of having to have his own attorney file a motion to quash. Because it's he's going to have to pay an attorney. Since the case is in Arizona, he's going to have an Arizona attorney, either one that's affiliated with his attorney or retain an attorney in Arizona to file a motion to quash. So it's going to be an expense and a hassle for Nate. And maybe at a minimum, that's what she's hoping, is that she's going to cause him inconvenience and expense. So no question, she's spiteful. Hey, Rachel, have you heard whether Proctor being fired will affect the other non-Reed cases you followed that he was on? Birchmore, and I'm blanking on the name of the other one. It's Brian Walsh. Those are the two sort of high-profile cases. I think Proctor being fired is going to redound in these cases for a very long time. Now, my understanding is that the state is not going to call Michael Proctor, but the defense would be insane not to call him. Now, the difference is that if the defense calls Proctor in Karen Reed's case, they're going to be asking him direct questions, and they're not going to be able to use a lot of cross-examination techniques. However, if they can convince the judge that Michael Proctor is a hostile witness, then they can use those cross-examination techniques. It would not surprise me at all if they asked the court to treat him as a hostile witness, because obviously he was a state actor. He was the lead investigator on the case. And I can't imagine that he is going to be overly friendly to the defense at this point. Although the Commonwealth really has thrown him under the bus, and so has Judge Cannoni repeatedly. And, he may not be real happy about that. So who knows if he's amenable to coming in and rolling over on everybody. That would be pretty cool. But technically, realistically, I don't think that's going to happen. But Proctor, the lead actor on the case, being fired for his conduct in this case is almost like a silver bullet for the defense to be able to come in and say, how can we believe anything in this prosecution, in this entire court case? Because the lead officer withheld discovery, withheld evidence, and was fired, which is, again, a last resort for a police agency to fire him for his conduct in this case. It doesn't get any better than that from the defense standpoint. Yes, in the Birchmore and the Walsh case, they are going to be able to bring in his credibility into question by saying, gosh, Officer Proctor, in a different case, you were fired for misconduct in that case, right? Right. Well, how can we then presume that you were unbiased and honest in this case? So, Proctor is going to continue to be a smoking gun in those other cases, but nowhere is it going to be as strong as in the Reed case. So I anticipate that they're going to call and Proctor is going to have to get on the stand, and they're going to take him apart. They're going to take apart all of law enforcement. I mean, let's remember that they're still working on getting in an expert to testify on what proper police procedure would have been if they'd employed it. So good questions tonight. Let's take a couple more and then we'll wrap up. I promise that, God willing, and the creek don't rise, we'll be back on Wednesday to talk some more about these cases. Is Daubert the thing with experts in all states? I know it is in more than one. So this is a good question. Venus Gal, thank you. Daubert is a federal decision from the federal Supreme Court. Now, when a decision comes from the federal Supreme Court, that means it applies to all 50 states. So Daubert is the seminal case in the federal government, in the federal Supreme Court. So you often hear them talk about Daubert. Well, in the Reed case, they talk about Daubert-Lanigan. Lanigan is the case, the Massachusetts Supreme Court case that talks about experts and how you qualify experts. So they say Daubert/Lanigan because that's the state decision. Now, as we've talked about, states can be more liberal in the way that they interpret a statute, or more liberal in the way that they enact a statute that guarantees someone's rights, but they can't be less than what the Constitution and the U.S. Supreme Court guarantee. So it's likely, I haven't read Lanigan, but it's likely that Lanigan just sort of expands on Daubert and how it applies specifically to Massachusetts cases. But that's a really good question. Now, Glossop, the one we talked about tonight, that's a federal Supreme Court case. So it is going to have impact on all cases all over the country. So that means it could be used in Reed and it could be used in Delphi, even though Delphi is Indiana and Reed is Massachusetts. So really good questions. There are some states where the state has a slightly different approach to experts. And so they use kind of a hybrid of Daubert and their own state statute. But for the most part, you hear Daubert, because Daubert, one of the things the Supreme Court is really good at is laying out like a checklist of what has to happen in order for the expert to be qualified in this case. So Daubert is very clear about the things that they have, that the proponent of the expert has to prove in order to bring the expert forward. Let's take one more question. Don't forget, I always point the wrong direction. Children of Darkness and Light over here. This thing is still available if you haven't picked up your copy. If you have a copy and you would like a book plate, an autographed book plate for your book, please drop your email, or actually the best thing to do so that your address doesn't go out all over YouTube is to email me and ask me for a book plate. I am happy to send them out with a couple of stickers, and then you'll have an autographed plate to tack into the front of your book. So please do that if you would like one. Last question, Venus Gal. Nate knows he's on Lori's list regardless, so whether served or not. Okay, this is a good question. There are some instances where a judge will say, regardless of whether you were served, you had actual notice, but subpoenas are not one of them. He will actually need to be handed a subpoena. And so I'm sure that will happen. There's no question that the process that Lori is having to use because of her, because she's in custody, is cumbersome. So there's no question about that. And it may just be that she is having trouble getting those subpoenas where they need to go. And remember, she's in Arizona, Nate's in Idaho. She may also just decide that it's not worth the trouble, and she will, at the last minute, take him off her list, because she can revise her witness list really until trial starts. So it may, she may revise her witness list and drop him and figure she's created enough grief for him. So, but in order for him to be directed to come to court, and for that to be enforceable by a judge saying either come to court or we're going to put you in jail, it has to be served on him. So you guys had some great questions tonight. I hope that you guys enjoyed the little overview on Glossop, a little something different. And I hope that we covered most of the cases that you all are interested in. Once again, if you are interested in the nitty gritty of the Reed case, definitely check in with Melanie Little. All you have to do is search that on YouTube and you will find her. And Melanie and Little are spelled the typical way. So I want to thank everybody for being here. Thank you most of all to Jen, our moderator, who always does such a fabulous job. Thanks to all of you. I appreciate you being here with me. And stay with us for next week because we will be back. I don't have any more book-related travel coming up anytime soon, although I may at some point have some travel coming up on the new project, but I'll fill you in on that when I know. So until next week, thank you for joining us. I don't take for granted that you're all here with me. I appreciate it more than you know. So have a great week and we'll see you next week. Good night.